Today, we are going to start with an overview of the history and purpose of copyright law. We will then look at how to determine what materials you can use and how to find materials that you can use legally in a non-educational setting. In the 16th and 17th century, published works fell under the same kind of system as royal patent grants in England. It wasn't meant as a way to protect the rights of publishers and authors, but to give the crown a way to censor works and make money. In 1710, England passed the Statute of Anne, which recognized that authors should be the primary beneficiaries of copyright law and established that such copyrights should only have limited duration. That limited duration was 28 years at that point. However, it wasn't until 1886 that representatives from 10 countries created the Berne Union and adopted the Berne Convention, which pretty much was a treaty that agreed that countries would honor each other's copyright laws. The United States didn't agree to join until 1988. In the United States, copyright law is established by the Constitution, which explains that the copyright system is intended to promote the progress of science and useful arts, limited times to authors the exclusive right to their writings. The original definition of copyright was expanded to include authorship in other categories of works in 1976. At that point, it expanded to cover pretty much everything not covered by patents, but some categories of works, such as computer software programs, may be covered by either patent or copyright. The goal of copyright law, and of honoring other countries' copyright law, is to promote innovation and creativity. For instance, if a musician has to have a day job because their songs don't make any money, they will have less time to write music and will produce fewer quality songs. American copyright laws have historically reflected the United States' role in the world. When the U.S. was a young and developing nation, for instance, it didn't honor copyright laws from other countries because it wanted to be able to copy what was good for it. This is one of the reasons why 18th and 19th century British literature was so popular and continues to be so popular within the United States. A publisher could go to London, buy a book, take it back to the US, and print a copy of it for pure profit, rather than having to pay the author anything. This made it harder for some US authors to be paid for their own work. Ignoring British copyright law was good for profit in the short term, but actually ended up affecting the development of American literature. The fact that magazines were more likely to pay for short stories, where a sense of place is often extremely valuable, contributed to the development of the short story as an especially American genre. After the US became more of a world power and was producing its own works, it wanted to be able to protect its own rights, so it started to respect the rights of other countries and formally adopted the Berne Convention. There are some major differences in copyright law between countries. For instance, United States law awards copyright to businesses in regard to work made for hire, while other countries grant the copyright to individual content creators. Countries also differ a lot when it comes to copyright for sound recordings. An author or creator does not have to do anything in order for a work to be considered under copyright. Copyright protection in the US is currently valid for 70 years after the death of the author. If the author is unknown or the work is made for hire, then copyright is set at 95 years from the first publication or 120 from the date of creation, whichever is shorter. These times have continually expanded over the course of the 20th and 21st century. It is possible to make a case that the extension of time is largely due to the influence of Disney, as they try to maintain copyright protection for Mickey Mouse. Each time Disney is about to lose control over Mickey Mouse, the law is amended. Copyright for Mickey Mouse will run out again in 2023. What happens when copyright expires? When a work is no longer protected by copyright, it passes into the public domain. Generally, almost everything published before 1923 falls into the public domain. Age is not the only way that a work can become public domain, however. Public domain works may be copied, distributed, modified, etc. without any restrictions. Be careful, however, as editions, translations, new mediums, and other modified versions may still be under copyright. Whether or not a work is in the public domain, it is almost always best to give credit to the author. One example of a work in public domain is Jane Austen's Pride and Prejudice. This is why Seth Grahame-Smith was able to write Pride and Prejudice and zombies by just inserting phrases within the text of the original novel. In addition, he still gave credit to Jane Austen in the byline for the book. For more text in the public domain, see Project Gutenberg. While you may use works not protected by copyright however you like, works protected by copyright can be used in certain manners and circumstances. These uses fall under fair use. Fair use in the US permits the use of copyrighted materials in certain situations with certain stipulations. Most things fall under fair use if they are used for education, news reporting, criticism, parody, and home consumption. Fair use law can be complicated and has been interpreted differently in different courts. Most incidents of fair use are accepted if they are transformative, not for profit, use limited parts and not the whole, and are not a substitute for the original. When determining whether or not a work falls under fair use, you need to carefully consider these four aspects for each individual work. Memes, for example, can fall into different categories. Tolkien's estate and New Line Cinema are very unlikely to sue someone for a one does not simply meme. But Getty Images has sent letters to people who use memes with their images. The distinction is partly because of the original format. No one is going to think that seeing Boromir declare, "One does not simply walk into Mordor," is a substitute for actually watching the film. However, it could be argued that seeing the image even with text on it may affect a viewer's desire to pay to see or use the image. Err on the side of caution and consult the legal department where you work if applicable. Up until now, most things that you have made that include media, images, short videos, that kind of thing, mostly fall into the educational fair use part of copyright law. You've been taught that including images in a presentation is one way to avoid death by PowerPoint, for instance. However, once you leave academia, you technically can no longer pull any images you find on Google to include in your company documents, as you no longer will be protected by educational fair use. In addition, if you write text for a company in the US, that text almost always will be considered owned by the company rather than by you. It counts as work made for hire. On one hand, this means that you need to be aware that you will not own the rights to the work you create for the company. On the other hand, since the company owns the copyright, this means that you can use text written by others when making documents for the company. For instance, if the company has an About page on their website, you can lift that text and use it unaltered when writing a new hire handbook, as both pieces of writing will be owned by the same entity. Though credit where credit is possible is best. A person from another company, however, could not do that. Made for hire varies from country to country and between multinational companies. Some companies award ownership of copyright to individuals even if the work is made for hire. Finally, in the US, a legally binding contract's terms override the law altogether. For example, the contract could state that an employee's copyright in the works are owned by the company into perpetuity. This contract clause governs regardless if it conflicts with the law. This information may be particularly applicable to you if you ever work for a multinational corporation. Often reused text that has standard wording is called boilerplate text. For instance, certain phrases or paragraphs appear almost identically word for word in different contracts, and certain coding phrases are of necessity the same in multiple software programs. Boilerplate falls into a different category and under different rules altogether. Other than works in the public domain are used within the guidelines of fair use, what other types of media can you use freely? One particular type of media is open source software. Code is text, so most, though not all, software falls under copyright law rather than patent law. Some software, such as Ubuntu, a form of Linux operating system, Firefox, and OpenOffice, are open source. This means that multiple people work together to create, improve, and debug the software, and anyone is free to use the software, look at the code, make their own modifications, and redistribute it. The kind of creative collaboration used within open source software is a type of crowdsourcing, which is becoming more and more common in a variety of professional, artistic, and scientific endeavors as technology provides more methods to allow more people to collaborate at great distance. Finally, another type of license that will allow you to use various forms of media for your own projects with some restrictions is Creative Commons licensing. Earlier, I mentioned how the goal of U.S. copyright law is to encourage innovation and creativity. There is another school of thought that sees problems with the extension of the time limits of copyright law in particular, pointing out how arts and culture often build on each other and copyright law tends to prohibit certain types of creativity. One term often used by people who want to make their work available for others to use freely, free as in freedom, not as in no money, is copyleft. There are a few different ways of marking a work as copyleft, and Creative Commons licensing is one of the most common and widely accepted. In the US and some other places, copyright is automatic. You do not have to file for it. So, if you want your work to be freely available, you need to mark it as such. You can only mark your own work with Creative Commons licenses. When creators make their own work available through Creative Commons licensing, they use these symbols to indicate how the work can be used. Only when given attribution, only if a new work is released under the same licensings, only if the new work is unmodified, and only if the work is used for non-commercial purposes, etc. And then, of course, there are licenses which include a combination of these features. There are 6 different licenses, and they range from less restrictive to more restrictive. You most likely want to look for works marked with CC BY, meaning that you can use the work however you want as long as you give attribution to the author. Another option is CC0, which is the equivalent of no rights reserved. Feel free to use works that fall under the other licenses as long as you pay attention to the rules for each. So how does this apply for you? As I mentioned earlier, much of your work so far has been covered by educational purposes, under fair use. Now, however, for the purposes of this course, we will pretend that educational fair use doesn't apply, as it will usually not for work you perform for a company. Therefore, here are some resources you can use to find work of various forms of media either in the public domain or published under Creative Commons licensing. First, you can use a Google image search under a few conditions. Select Tools and choose to only find images licensed for reuse with modification for commercial purposes. Even with this tool, however, you still need to go to the actual page to find additional information, such as whether or not the image needs attribution if you use it. Secondly, Wikimedia Commons is a collection of images, recordings, and some other types of media. Scroll down to find licensing and attribution info. Thirdly, avoid Microsoft Clipart, as the licensing and what you can do with it can get pretty complicated. Instead, go to openclipart.org to find clipart that you can include without attribution. Finally, if you are looking for music, perhaps to include in a video project, consider searching CC Mixter and pay attention to their instructions for attribution and licensing, which may vary from song to song. When used correctly, copyright works to encourage creativity and innovation. It's an important thing, so don't just ignore it. Instead, use the opportunities in this course to explore ways of finding media that you can use without breaking the law.